JBN, we keep you informed. I am Michelle Jones, and in the news, Cocopese ller Rushane Barnett gets life in prison. Please remember to subscribe, like, share, leave us a comment, and click the notification bell to receive our daily news items. Cocopese ller Rushane Barnett, who slaughtered his 5 family members, was this morning sentenced to 5 concurrent life sentences. Presiding Judge Justice Dayton Pusey, who handed down the sentence in the Home Circuit Court, has ordered that he served 61 years and 8 months before being eligible for parole. Pusey highlighted, among other things, the brutal, vicious, and serious nature of the crime.
May it please you, my lord.
Yes, ma'am.
Before the court is Rushane Barnett. He is represented by my learned friend, Miss Tamika Harris. I appear for the prosecution in this matter.
Yes.
And appearing with me is Mrs. Andrea Martin Swaby, Senior Deputy Director of Public Prosecutions.
Yes, ma'am.
In this matter, my lord, on the 23rd of July, 2022, the accused Rushane Barnett pleaded guilty to 5 counts of murder.
Sorry, madam. I think that's the 28th of July.
Sorry. Oh, I'm sorry. The 8 looked like a 3. Thank you.
Yes.
The 28th, thank you, my lord, of July. On the last occasion that this matter was before the court, the sentencing hearing was commenced, and both my learned friend, Miss Harris, and I made our submissions. After your lordship heard the antecedent report and also the social inquiry report and victim impact statements from relatives of the deceased, your lordship reserved judgment in respect of the sentence to be delivered until today's date. May it please you, my lord.
Right. Thank you very much, madam. The court had taken some time to go through with this matter and to ensure that it's able to set out its reasons in relation to the sentence in this matter. As we've seen, this is a matter which has had some involvement of the public. And so therefore, the opportunity to do that, I thought it was necessary to ensure that we could do it as clearly and hopefully as concisely as possible. And so I'll proceed in relation to the court's ruling in relation to sentence. In the morning of the 21st of June, 2022, the bodies of 5 persons were discovered at their home in Cocopese, Chapelton, Clarendon. Deceased are 31-year-old Kamisha Wright and her daughters, 15-year-old Kimanda Smith, 11-year-old Shara Lee Smith, and 5-year-old Rafaela Smith, and her son, Keshawn Henry, who was not yet 2 years old at the time of his death. Each body had multiple stab wounds, and I'm not going to go into the details of the injuries. They have gone into the public record, but in circumstances where they are relatives of the deceased here, I will avoid them as much as possible. This is a crime for which adjectives and descriptions were insufficient, and which shocked and horrified a nation, even this country, which has unfortunately gotten too used to murder. The perpetrator, who is a cousin to the family, surrendered to the police, and by the evening of the 22nd of June 2022, had provided the police with a caution statement and participated in a question and answer session, having been provided with legal advice by duty counsel. And for the avoidance of doubt, just to understand that the counsel was present when he gave the caution statement and present for the question and answer to advise him. The Director of Public Prosecutions exercised her powers to enter a voluntary bill of indictment to bring this matter before the Home Circuit Court. This process, they enter in the voluntary bill, dispense with the need for committal proceedings in the parish courts. The committal process in the parish courts is an important one which helps to ensure that all evidential and legal aspects are in place before the matter comes to this court, which would try matters like this. However, the parish court would not have been able to accept a guilty plea or sentence the accused. In circumstances like this, where there was evidence in place and was reasonable to do so, the DPP was exercise her powers to bring the matter directly to the court that can receive the plea and deal with the matter such as sentencing. At the first hearing before this court on the 28th of June 2022, the Director of Public Prosecutions also served a death penalty notice, indicating her intention to apply for death sentence upon conviction and at the time of sentencing the accused. At that early appearance in court, the accused indicated an intention to plead guilty even before he had the benefit of legal counsel assigned to him in this court. Using the facility of the Legal Aid Act, this court appointed counsel to represent the accused and had at that time ordered that a forensic psychiatric report, which was sought by the Crown, would be done on the accused man, for the accused man, that is. On the 28th of July 2022, the accused formally pleaded to 5 counts of murder before this court. A sentencing hearing was held on the 22nd of September 2022. Sentencing hearings are not unusual matters. Usually in most matters, there will be time when the court will hear from the parties, will hear the information that is necessary for sentencing and make a determination. But it is specifically required in murder cases under Section 31E of the Offences Against a Person Act. At the sentence hearing, according to the legislation, the court, and I quote, "The court shall hear submissions, representations, and evidence from the prosecution and defense in relation to the issue of the sentence to be passed." In the sentencing hearing, the court considered the caution statement and question and answer statement given by the accused, the victim impact statements of the 2 relatives of the deceased, the social inquiry report, the report of the forensic psychiatrist, and the antecedent report from the police. The court then heard from the Crown in the person of Mrs. Llewellyn, the Director of Public Prosecutions herself, who indicated that the death penalty notice was withdrawn by operation of law. She indicated that the accused having pleaded guilty, that it was no longer appropriate for the death penalty to be an option, and therefore the notice was withdrawn. The learned King's Counsel then went on to indicate the Crown's view of the sentence, in other words, indicated what principles and what authorities should be relied upon, posed that to the court, and submitted to the court that the court should arrive at concurrent sentences of life imprisonment with eligibility for parole after serving 60 years and 9 months. Counsel for the accused also made submissions, as was her duty required of her by the court when she was assigned. She submitted that the sentence imposed would be life sentences with eligibility for parole after 45 years. It should be noted that under Section 3 of the Offences Against the Persons Act, once the option of a death penalty has been removed, the sentence for murder in these circumstances is a life sentence, and the court shall determine the period before which the accused shall be eligible for parole. By these circumstances, when I say a matter in these circumstances, I mean this case being a case of multiple murders which are done at the same time as set out in Section 3, open bracket 1, capital A, close bracket of the Offences Against the Person Act. I say that in Jamaica, life sentences mean that the person is liable to be incarcerated for the rest of their natural life. There are some jurisdictions where a life sentence has been defined by a set period of years. This is not the position in Jamaica, certainly in relation to the sentences in these circumstances. And eligibility for parole means just that at a designated time, the person may apply for parole, and if they are deemed sufficiently suitable, they may have supervised release from custody. It is by no means automatic, and the parole board will look at several factors, including the prisoner's behavior in custody, the nature of his offense, and whether he's still a threat to society, and if there's anywhere suitable to receive him. I'll go on to indicate that a person on parole is always under supervision and can be recalled at any time. In short, eligibility for parole does not mean an automatic release from custody. The most that a prisoner can hope for in this sentence is supervised release under stringent conditions. And I say the most that the prisoner can hope for, in that the impression may be given, and it seems to have been in some discussion, that it would mean that once eligibility for parole would come, the person would be a free person. That is not the situation in terms of the law. I emphasize this because despite the fact that the media reports that I have seen, and I don't claim to have seen many or all of them, correctly indicated that the sentence proposed by both the Crown and defense are life sentences. But some persons seem to have understood that the time which was suggested before the person was eligible for parole was the sentence itself. So, for those who are interested in the short answer to what the sentence the accused will receive, it is that he'll be sentenced to 5 concurrent sentences of life in prison. The major issue for the court to decide is the relevant time he should serve before being eligible to be considered for parole. I'll now briefly detail the material before the court in the sentencing hearing, then speak about the sentencing process, and finally I'll indicate how I've come to my decision in relation to the sentence. The court considered the caution statement which the accused gave to the police shortly after coming into custody. This was a voluntary statement in his own words, which he gave after advice of counsel was provided to him and while counsel was present. He also gave a question-answer statement where, after again legal advice and in the presence of his lawyer, he answered questions put to him by the investigators. The court also had statements on file from persons who found the body and spoke to the accused before the incident. We also had read into court the victim impact statements of Mrs. Gwendolyn McKnight, the mother of Kamisha Wright, and therefore the grandmother of Kimanda, Shara Lee, and Rafaela Smith, and Kishon Henry, and Mr. Kishon Henry, the father of little Kishon Henry. The victim impact statement is a relatively new development in our courts. It allows the courts to hear from the persons most directly affected by the crime and provides the victim with some involvement in the sentencing process. The victim impact statement is usually read into court rather than being spoken by the family members themselves because of the trauma that the process may inflict on those family members. These statements are not intended to be a guide or to direct the court in relation to what sentence the court gives. Even if a view is expressed as to the severity of the sentence, or in some other cases, not in this case, the victims may express forgiveness. It is not expected to constrain or to direct the court, as the court has to consider the victims, but look globally at the other circumstances, the circumstances dealing with the society and the circumstances of the accused and the crime in coming to a sentence. So the victim impact statement is an important guide, but while one celebrates, if that word can be used, and invites the involvement of the persons who have been affected in this way, it is not to be seen as something which is going to bind the court or constrain the court in any way in terms of how the court would sentence. A social inquiry report was also provided by the Probation Aftercare Services Department of the Correctional Services. The court received a detailed report with the assistance of social workers in the corporate area, Clarendon and Trelawney. The report spoke to the upbringing of the accused, how he's perceived in communities in which he resided. It also included a summary of interviews with the accused himself and relatives of the victims, including Ms. McKnight, Mr. Henry, and Mr. Smith, the father of Kimanda, Sharalee, and Rafaela, and also other close relatives of the accused. It dealt with his health status, including his mental health, and makes recommendation as to sentencing. That report was not read in court because persons often speak freely with the social workers about the accused, and some of this is kept confidential. Matters that are confidential in court in this way are kept confidential to protect witness from public backlash, and sometimes to allow officers of the court who do these investigations to get private and personal information which can assist the court in sentencing. But I need to emphasize that confidential does not mean secret, because all the material before the court has to be made available to the accused man and to his counsel. And in this case, as in many other cases, aspects of the social inquiry report was used by the defense in the plea for leniency. So I wanted to deal with that just to indicate that even though we did not make public, and especially in terms of the fact that we were being live streamed then also, the social inquiry report, it wasn't because there were things which could not be checked and things which were said behind somebody's back. These were things which all parties in the trial would be aware of, but there are things that we would not necessarily want to make public in the circumstances of most cases, and in particular in the circumstance of this case. The court also had access to a psychiatric report from Dr. Clayton Sewell, a forensic psychiatrist. The summary of Dr. Sewell's report is that the accused has no major mental illness, but that he displays features which suggest that he has an antisocial personality disorder. The doctor found that the accused man, understood the nature of the offense and was not acting under any abnormality of mind when he committed the offense. Dr. Sewell indicated that although the accused indicated that he heard voices, he was unable to see in his examination that there was any signs of delusion in the history of the accused before the incident. I'm going to read in particular an aspect of the report, just four of the several findings, because I believe they are relevant in relation to how the sentencing of the accused man. The doctor indicates that the accused's description of the events is not in keeping with statements previously attributed to him. Has also indicated that he displayed no behavior and reported no current symptoms suggestive of a major mental illness. He appeared eager to deflect responsibility for the alleged offense to his cousin's mother by claiming that she caused obeah to be on him. He appeared to be superficially charming, deceitful, lacking in empathy and remorse at the time of evaluation. And finally, I found this instructive. He expressed the desire to be given oral medications, placed in a single cell, and to remain in custody for a year before being released on the current charge. We also heard from the antecedent report from the police, which confirmed that the accused had no previous convictions. The court in sentences considered the law which governs the offense, the legal principle of sentencing set out in legislation and other legal precedents before the court, and also looks at comparable cases where persons were sentenced for similar crimes. And I'll go through that very briefly. Let me deal with the statute firstly. It was indicated that in these circumstances, the sentence would be life with eligibility for parole after 20 years. This is because the Offences Against the Person Act makes a distinction as to the penalty for murder in different circumstances. This falls under the most serious category where murder is committed either committed in furtherance of burglary or housebreaking, B, asked in relation to a dwelling house, C, robbery or any sexual offense, or D, in this particular situation, multiple murders, whether committed on the same or on a different occasion. The relevant section of the Offences Against the Person Act, which is section 31C, states that in a case of a person convicted of murder, the following provisions shall have effect with regard to that person's life eligibility for parole, as if those provisions had been substituted for section 6(1) to 4 of the Parole Act. And that's, in this case, where court imposes a sentence of imprisonment for life pursuant to section 1A and the other sections I mentioned, the court shall specify a period being not less than 20 years, which that person should serve before becoming eligible for parole. The Criminal Justice Administration Act, in its 2015 amendment, codified and standardized the common law discount or reduction in sentence that is provided for someone who pleads guilty to an offense. Forgive me that I need to spend some time going through this because this is a particular area of law that I need to deal with in detail. When I say standardize and codifies, what I'm saying is that in common law, in other words, not law which is written down from something that comes from Parliament, but law that the court has put together over the years, not just in Jamaica, but in the entire common law jurisdiction, which includes England and other courts, other countries which have the same type of law, is that whenever somebody pleads guilty, they would be given a discount. In other words, they would be encouraged to plead guilty by not getting as hard a sentence as if the matter had gone to trial. What the amendments to the Criminal Justice Administration Act has done is to put that in a law and standardize it by saying these are the circumstances in which the discount would be given and these are the discounts that would be given. It's set out in the legislation that based on the time the person pleads guilty and other things, they would be given a discount, a maximum discount of, it starts at 50% and goes down, I believe, to 15%. That legislation, however, only allows a discount for murders under Section 2, subsection 2 of the Offence Against the Person Act, and not for offences which come under Section 2(1) or Section 3, open bracket 1, capital A of that legislation. Section 42C of the Criminal Justice Administration Act specifically excludes this section of the Offences Against the Person Act from getting any discounts at all. What that means simply is that the offenses, the multiple murders that this accused man has been charged for, based on the legislation, does not come within the rubric that the legislation allows for him to get a discount. There is, however, a subtle legal argument that because the discount existed previously at common law, even though the statute does not provide for such a discount, that the court could still give a discount for this kind of offense. So even though 42C of the Criminal Justice Administration Act exclude a discount provided by statute, there could be an argument that there could be a common law discount. I do not agree with that proposition, that there would be a common law discount, because I am of the view that the Parliament, having intervened, having codified and standardized the common law discount, then that is the relevant law in the matter, and the common law ought not to interfere. However, I may be wrong in law, but even if I am wrong, that and there still is a common law discount available for this accused, I would not give any discount in the circumstances of this case. The circumstances of this case that would dissuade me from providing a discount at common law are as follows. One, there was ample compelling evidence pointing to the accused. He was a person of interest almost immediately after the bodies were found. Clothing and a knife were discarded near the scene, and even before forensic tests could link him to the event, he was, as I say, a person of interest, and he was the one who had been living with that family. Secondly, the brutal nature of the offense means that any discount would bring a sentence that this court would give below what I would think would be a fair and appropriate sentence. And in those circumstances, I would not give a discount. And finally, the third reason is that the fact that the death penalty is no longer being considered is a significant benefit for this accused. This is a matter which could have come between the elusive requirements in Chimmingham and the Crown, in which the Privy Council indicated that the death penalty would be imposed in only very serious cases, the phrase being the matter, a case would be the worst of the worst. In my view, were to have reached that stage, this is clearly a case that would, at the very least, approach that category, and very likely, I think, would have been one where there could be a death penalty. And so, as I've indicated, of course, before, that the death penalty notice was withdrawn as a matter of law, and the indication being that he, having pleaded guilty, then the more he had to be relieved of the more serious penalty. Having indicated that, I'm going to just pass into the Jamaica sentencing guidelines, which are important for us to note at this time. This is something which has been developed by the judiciary and has been approved in several judgments of the Court of Appeal. There are things which are open for the public, and they set out the process of sentencing in different ways. But before the sentencing guidelines were created, were put in one document, there were general sentencing principles which were in various cases and which would be in different legislation. What the sentencing guidelines do is to bring this into one document, which is an easy reference for attorneys, for judges, and also for members of the public who are concerned about how the court sentences persons. The guidelines, as I've said, have now been approved by the appellate courts, and therefore they are not just guidelines, but they bind and direct all courts which are dealing with matters such as this. And so we have to follow those guidelines, and I will refer to them in passing. Let me just say that the court is always cognizant of the fact that sometimes sentencing seems to be a miraculous thing which the judge does on his own. But it is in fact, as these principles set out, and I won't go through all of them in any great detail, but the fact is that these are measures that the court has to follow. And the position now is that the learned DPP, in situations where sentences may be unduly lenient, have an opportunity to appeal, and the accused person has an opportunity to appeal also. So the court is not at liberty just to make a sentence based on its own initiative, but it follows in the sentencing guidelines, and the sentencing guidelines have distilled cases such as the case of Misha Clement and Dennis Ralston, and it dictates that in the process of sentencing, the court should firstly identify the sentencing range, determine a usual starting point for the sentence, consider the aggravating factors, consider the mitigating factors, consider any situation where the court puts these factors together, makes some assessment, and then comes to a sentence. We have no precedent in our annals, and if I may dare say, I hope we have none after today, aside from this one, unfortunately. The case of Jeffrey Perry is a case which is closest to on point with this matter. In that case, the appellant had been convicted of 3 counts of murder. One deceased aged 4 years, one 13 years, and 15 years. They were stabbed to death by the appellant in that matter. Mrs. McIntosh, Justice of Appeal, in delivering the judgment, noted that the court took into consideration a number of mitigating circumstances to include that the appellant had been diagnosed with obsessive compulsive disorder. He had no history of criminal or violent behavior. He had assisted the police in the investigation, and there was no evidence of motive, and that he had already spent 7 years in custody since the commission of the murder. He had originally been sentenced to murder and was commuted to life in prison with eligibility for parole after 45 years. Taking into consideration his pre-sentence time in custody, this means that it was effectively a sentence of 52 years before eligibility of parole. I want us to also refer to a recent case that this court has. It's the case of the Crown against Mark Henry. And this is a judgment of my sister, Justice Shelley Williams, which was done on the 14th of October. And this similarly was, I believe, 3 murders, and the accused was sentenced to, one moment for me, please. He was sentenced to serve 49 years and 6 months before the possibility for parole. So it was, and she also used Perry among other matters, and so therefore it is within the same range. For me, therefore, the minimum sentence, as we've said, is 20 years before eligibility for parole. And I would agree with the Crown that for this matter, the range would be life with 20 years as a minimum and maximum of 60 years before eligibility for parole. The starting point, which would be used for this accused, based on the seriousness of the offense, would be 55 years before eligibility for parole. Based on the nature of the offense, the multiple murders include that he should be close to the top of the range. For the aggravating factors, I considered that this is the murder of a family in their own home, a place where they would consider themselves safe. Secondly, that there was a breach of trust. The accused inflicted on the family that welcomed him into their home as one of their own. I see this as a separate factor from the location of the murder. Thirdly, the multiple wounds on each of the deceased by the accused, which displays and again, I struggle for adjectives, a direct viciousness in carrying out this attack. Fourthly, the attack was contemplated ahead of time, that the accused told someone that he was going to kill some people. And also in his caution statement, he indicated that he came to the conclusion that Miss Wright was looking at him away, and so therefore he acted. Fifthly, his lack of remorse was commented on both by the psychiatrist and the social worker who interviewed him. In the social inquiry report, and I let me read from that. The social worker who would have done thousands of matters like this says of him, his claim to disbelieve upon contemplation of this behavior flies in the face of his generally nonchalant disposition while being interviewed, as well as his expressed frustration in being, quote, tired of the questions. All told, his mannerism was not indicative of one who possessed a full appreciation of the magnitude of his act and the devastation caused, and does not appear to be remorseful concerning the same. We did have some discussion with counsel while this was being in the sentence hearing about lack of remorse. But I accept the conclusion of the trained psychiatrist and the trained probation aftercare officer and the observations that they've made in terms of the accused man. For these aggravating factors, for each of these aggravating factors, I would add 2 years to the time before parole, which would total 10 additional years, and a total of 65 years before eligibility for parole. The mitigating factors are his early guilty plea and his lack of previous conviction and his youth. I have not weighed the factors, especially of the lack of previous conviction and his youth, greatly, because the enormity of this offense, when the first offense of an accused before the court is as serious as this one, then the fact that he has no previous conviction is less important than if he was charged with a simple wounding or an assault. I would deduct 1 year for each of these factors. As I said, I am crediting him for the early guilty plea, but as I've also indicated, the fact that he is not in penalty of death, I think is also a significant boon. Having deducted this period of time, from these 3 years, it would be a sentence of 62 years before eligibility for parole. I'd also have to deduct the time he spent in custody, roughly 4 months. And then, therefore, his sentence would be on each offense for the lives of Kamisha Wright, Kimanda, Shirley, and Rafaela Smith, and Kishawn Henry. A life sentence on each count with eligibility for parole after 61 years and 8 months. The sentences are to run concurrent. Will the accused please stand? I want to say one thing, if I've been committed to make one particular comment in relation to this and in terms of this particular process. That is that what we need to remember in this matter is the lives of the persons who lost their lives. And I have been deliberate in mentioning their names continuously. I have also been deliberate in not mentioning the name of the accused man, because it is my eternal hope that we will forget his name, although it seems as if there has been quite a lot of his name has been wide and abroad. In the same way that with other persons who have committed similar offense, Mr. Perry in particular, they become a footnote and they are only remembered when we look for legal precedents. I would hope that we remember these persons, Ms. Wright in particular, from the victim impact statement and other things, was significant as a woman, a young woman, who was looking after her 4 children and also studying and finding time to run a shop at the time. These 3 children, Commander, Sharalee, and Rafaela, would have been in school and had their own hopes and dreams. The information from their father indicate that the possibility was being looked into for them joining him overseas in other places. And Kishan Henry, his family will not have the opportunity of hearing him, of seeing him go to school as a child at that particular age. I think it's important also to remember, in particular for Miss Wright, that she was somebody who, with all the difficulties that she had, was still able to be generous enough to try to help somebody who was in need. And I think that it's important for us to celebrate that generosity and don't think of it as something which opened her to the situation that happened. In other words, it was not her fault. It was others who were responsible for what they did. So, Mr. Barnett, the order of this court is that you will be sentenced to life in prison. There are 5 sentences, 5 concurrent sentences, and that you will serve 61 years and 8 months before you are eligible for parole. Thank you very much, sir. You can have a seat.
JBN, we keep you informed. Please remember to subscribe, like, share, leave us a comment, and click the notification bell to receive our daily news items.